This is Jenna Ellis in the morning.
Good morning. It is Wednesday, June 10th, and not only is this Family and Faith Month across the country rather than Pride Month, even though there are still the few vestiges of attempting to lean in to Pride Month. More on that later on in the show. But June typically means for the United States that we're getting into the territory in the Supreme Court season of some of the more controversial cases and perhaps some of the more politically impactful cases and some of the outstanding cases that the Supreme Court has yet to weigh in on this cycle are tying together a central question of who gets to govern America, the president, Congress, the states, federal agencies, or federal judges. And I think it's a really important question that we need to ask and answer and perhaps not leave to federal judges. Well, let's welcome in Don Brown, who is a former prosecutor and former JAG officer. And Don, this is a really fascinating question that you have raised and how all of these cases tie together. So, how is the Supreme Court going to ultimately answer this potentially in a series of forthcoming opinions?
That's a very, very good question, Jenna. One case that is going up to the Supreme Court that may be reached is an important case governing who controls the United States military. That's the Talbot case, in which a U.S. District Court, Court of Appeals for the District of Columbia, by a 2-1 vote, struck down the president's order banning transgender recruitment, or upheld an injunction partially against it. And I know that the Secretary of War is appealing that directly to the Supreme Court. And there's a separation of powers question in all these cases. You know, whether the courts have power over the military, they don't, in my opinion. There's another case called Trump v. Slaughter, where the president tried to fire the FTC commissioner, and that's going to reach the court. You know, who has the authority to do that? Article 2 gives the executive that authority. So there are a lot of separation of powers questions that are going to be brought. And I've made the argument for some time now, of course, that the judicial branch is limited. If you go back and read Federalist 78, when the Constitution was first passed in Philadelphia in 1787, it had to be ratified. The states were afraid of overreaching federal judges. And in the Federalist Papers at Federalist 78, Alexander Hamilton wrote that the judiciary is to be the weakest power, the weakest branch by far of all the government, of the branches, and shall have no power to issue injunctions over either the executive or the Congress. And we've come a long way, and some of these cases are going to touch on those. The Slaughter case will certainly touch on the president's authority as executive over the executive branch, where they can fire these commissioners, these heads of these agencies. I certainly believe that he can. That should be the right outcome. And if the Talbot case reaches, I think this is a case that touches on national security. I've raised the question: what's going to happen if USS Ronald Reagan sails out of San Diego at the president's order for some crisis in the Middle East, and some Democrat judge issues an injunction to stop it? What's the president going to do? So these are some very, very important questions that are going to be looked at, not to mention the birthright citizenship case that's coming up. It's going to determine whether the president's interpretation of you got to be born, you can't be an American citizen if you're born illegal parents. That plus the women's sports case coming up. So it's going to be an active session for the next few weeks with some significant decisions for sure.
Yeah, and I love how you framed that. And also, anyone who quotes the Federalist Papers on my show, I'm an automatic fan of. And so, you raise this really important question of judicial review and the power and the capacity of the Supreme Court to have the jurisdiction and the authority and the ability to hear these cases and render an opinion at all. And of course, the Supreme Court was supposed to be limited. And I've argued for some time that the one thing that perhaps the founders didn't anticipate, because they argued, as Hamilton did, that the Supreme Court and the judicial branch is so limited, and so it's the weakest branch, and therefore we don't have to be worried about an out-of-control judiciary, is that they didn't have a check and balance sufficient to vacate certain rogue judges or overreaching opinions in a timely and consistent manner. And so when a federal judge, for example, in your hypothetical, issues an injunction against the USS Ronald Reagan, what is the president supposed to do if that is ultimately an unconstitutional action by the federal judge? We can't just simply ignore the judicial branch. I mean, that would turn into chaos. But we also can't bow to rogue judges or extrajudicial authority even if they're acting under the auspices of jurisdictional authority. So how would you solve that problem that I think is implicit in our current framework? In a perfect scenario?
Well, we have to understand, first off, there is a clear delineation of separation of powers. It is one of the most fundamental concepts to our constitutional republic. And stop and think about it. You've been before federal judges. I've been before federal judges. By the way, I was a fan of yours before you were a fan of mine, so thank you. But we've both been before federal judges. Think if Donald Trump comes in, some judge, like Frank Whitney, a friend of mine, is one of the senior federal judges here in Charlotte. If he were to overrule an objection hearsay, objections overruled. Think if Donald Trump or Chuck Schumer or any Republican senator, Lindsey Graham, came in and overruled Judge Whitney's decision on hearsay. That is a clear separation of powers from the executive branch or from the legislative branch. And so when you look at Article 3, you've got to go back to the basics. The judicial power of the United States, this shall be vested in one Supreme Court, which is the only branch of government that's judicial. And here's the key, Jenna, and such inferior courts, plural, you hear that, inferior courts, as Congress may from time to time ordain and establish. So these courts are inferior courts. The courts of appeal in D.C. or of the 13 circuits are inferior to the Supreme Court, and the 77 district courts are superior to the courts of appeals. And the Supreme Court is inferior, according to Madison, to the other two branches. So what you're seeing, and the Supreme Court kind of cut down on this last year just a little bit, hopefully, with the Cass decision. But what you're seeing, as the Costa decision, what you're seeing is one of 677 judges trying to issue orders and opinions to override the executive. When you look at Article 3, those courts are supposed to be interpreting federal law, but they don't really have. They're a separate branch from Congress and from the president. And so they have, from the very first case, Marbury versus Madison, on judicial review, there's been kind of what we call the military mission creep, where they have taken more and more authority, but they're not the ultimate answer on every dispute. So, for example, with the transgender recruitment policy, all right. So President Trump banned that both in his first term and now in this term as well. Secretary Hegseth has signed the order, and executive orders have gone through, and recruitment of transgenders in the military is stopped. And it should be, because it's dysphoria. It's a gender dysphoria. So when I was in the military, that would be considered to be, something that's a psychological disorder they drum you out for. You got to have good order and discipline. Well, it's none of the court's business. If there is somebody said, well, what if the president issued an executive order to prohibit, somebody based upon race? Well, that's a different question, because that is an immutable characteristic. But still, the United States military, for example, the authority and regulation and power over it is divested between two branches: the Congress, which has the authority to raise an army and a navy and to set regulations, and the president, who's commander-in-chief, not the courts. So checks on the executive within the military are to be made by the Congress, not by the courts. That's what the Constitution sets forth. And over time, they have crept more and more in. You go back, there was a famous case during the Civil War called the Merriman, actually. And so in that case, what happened is the Chief Justice of the Supreme Court, Roger Taney, issued a writ of habeas corpus to President Lincoln to take this Confederate sympathizer, John Merriman, out of Fort McHenry, where he's being held, and bring him before the court. So you had John Taney, the Chief Justice of the Supreme Court, ordering President Lincoln to remove a Confederate sympathizer from a military prison and bring him before the court. You know what Lincoln did? Lincoln ignored the order because Lincoln understood Federal 78. It was an unenforceable order to begin with. And these judges are out of control, and I'm hoping that the Supreme Court is going to slap some of this stuff back. They'll come back again. But this decision out of D.C. in this Talbot case I'm telling you about, the D.C. Circuit, is 2-1, and the two justices trying to strike down the presidential order in the military are Democrats. One was supported by Obama, one by Clinton. So you're seeing politicized decisions, which is not what the founders ever meant for this to be. They would roll over in their graves if they'd known how far these judges have taken upon themselves to be little presidents and little members of the Congress themselves and try to make law. So it's got to come to an end, and I hope that this summer we're going to get some curtailing of this ridiculous, out-of-control train wreck we have.
So well said, and I hope so too. And it's ironic that the restraint of the judicial branch is requiring the Supreme Court to restrain its own branch. But a lot of this would be cured if, and some of these questions responded to constitutionally, if Congress would step up and actually do their job. I mean, it seems to me that as the balance of all of these powers are tilting in a runaway judiciary, and the Congress then is continuing to do less and less and less, and actually less oversight, less on the issue, for example, of birthright citizenship or nationwide injunctions. I mean, they could legislate and actually come up with a uniform rule on this and not require the Supreme Court to weigh in at all. But Congress, it seems like, is way more interested in their petty political fights and going on media hits, rather than actually doing their job of actually establishing common law and rules within their purview. And that's, to me, the most frustrating element of this is that, President Trump, through executive orders, so forth, is trying to push these issues. But the president should have more limited capacity in terms of that type of rulemaking. And Congress, even Republicans, just don't seem that interested in actually governing.
Well, Joe, you make a very good point. A lot of people don't understand. Congress has authority over every inferior court in the United States. It doesn't have authority over the Supreme Court, which is a separate branch, going by the separation of powers. Back to Article 3, the judicial power of the United States is invested in one Supreme Court and such inferior courts as Congress. Hear that word, Congress, may from time to time establish and ordain. Every inferior federal court in the United States has been created by Congress. Congress could, if it wanted to, if the D.C. court's out of control unconstitutionally from one ruling after the other, could ban that court, could take it out. It creates inferior courts. It can end inferior courts. Congress has the political power to rein in these out-of-control judges. But you're right. They kind of like, for the large part, sort of fold their arms and go to fundraisers and would rather just delegate their responsibility elsewhere, just like they did when they created all these executive agencies during the administrations of LBJ and Franklin Roosevelt before that. They just gave rulemaking authority to executive agencies and basically abdicated their own responsibility. The Congress is the one of the three branches that's primarily failed the Republic, because it has abdicated this responsibility, and it needs to rein these courts back in, and it needs to get back to the business of making laws itself and taking away the authority of a lot of these agencies that essentially make federal law.
Amen. And we've got to take a break here, Don Brown, but so well said. And I think you've actually answered my question that, the U.S. Constitution does provide, if we just read it, does provide a pathway to rein in federal judges. It doesn't require actually just appointing good judges to rein in themselves. The answer is Congress, and it's our legislature and the lawmaking authority that is vested just in the Congress. And again, as I've been ranting about since Trump's second inauguration, that the Republican led Congress actually needs to do its job on a variety of fronts. If we're just so excited about the one big beautiful bill and that's all they're doing, but then they're out there ranting about, these rogue judges, but they're not actually proffering any legislation that's under their constitutional authority, then they probably don't even know. These members of Congress probably don't even know. But Don Brown, thanks so much. And we'll be talking about this frequently. We'll be right back with more.